Pam Docket.
Thank you to both of you. Council on 125-798 are welcome to come forward. As you do so, I'll just make a couple of additional comments. We do still have an empty chair, as we made obvious earlier. We are anxiously awaiting the swearing in of Justice Walsh, which we anticipate will happen actually fairly soon, but not in time for this docket. And so we will be sitting as a court of six on these cases today. And I will note that on the second case, Justice Rosen has recused from that case, so there will only be 5 of us sitting on that case. Thank you. Ms. Davis, you may proceed.
Michelle Davis, appearing on behalf of Mr. McCray. May I please request 3 minutes for rebuttal?
3 minutes is granted.
So the issue before this court today is that Mr. McCray was, through his plea, was found guilty of a low-level 5 drug felony and a low-level 8 felony. And so criminal history is important with those, especially. His trial counsel objected to the scoring of criminal history, and the conviction that concerns us today came from Illinois. And it's a fairly unique theory of liability that Kansas doesn't have. And on that basis, that's why defense counsel objected. And the state argued that Kansas has reasonable foreseeable. So it's interesting. This is more than just aiding and abetting, because in Kansas, if you're a participant or you're an aider, in most states, your level of participation doesn't matter. Once you're helping commit a crime, then you're guilty for the crime or responsible for it. This concerns something in addition. It was an additional crime committed by one of the participants. And so example would be the Mora case, where you're distributing marijuana. You're charging him with aiding and abetting in the distribution of marijuana. And then the person that he's with attempts to murder someone else. So this is an additional crime that's committed beyond the crime that you're intending by aiding and abetting. And that's what Illinois did. The difference is that in Kansas, you have to say the specific crime that you're aiding and abetting. In Illinois, you don't. You just have to allege that you're participating in a common design or scheme. You don't have to say what it is. It's in for a penny, in for a pound. So once you're participating in this common designer scheme, you're responsible for any crimes that are committed by another participant. It's like a felony murder without the murder. So you're committing the felony. Anything that results, you're responsible for.
Can I back us up a few steps to how we even get to considering the nature of which we'll consider Mr. McCray to have been a principal in that crime? Do you agree that we need to look to Wettrick for our test?
Yes.
And when I look at Wettrick, and this is a quotation from it, to be a comparable offense, a prior out-of-state crime must have identical or narrower elements. So we're all very comfortable with that statement. But I want to stress the next 3 words: than the Kansas offense to which it is being compared. When I look at the Illinois judgment, it reflects only one crime of judgment, and that's that aggravated discharge. It doesn't talk anything about how they determined McCray was a principal actor.
Yeah. And
so how do we handle that?
You have to go to the indictment. The indictment was very detailed in Illinois, and the indictment alleged not only the discharge of the firearm at the vehicle, but also the statute that provides this design. But
this language is the crime of conviction. And the crime of conviction is only aggravated discharge per the summary, per the journal entry. Right,
but in order to get that conviction, you have the elements, but you also have to have the conduct that supports the elements.
But we don't usually look to conduct.
But
in fact, we run into constitutional issues if we look at conduct. We usually just look purely at the statute.
Right, but
So how do we make that jump without adding to Wettrick in a way we've not done before?
When you're referring to the Illinois judgment, that's the judge's handwritten notes. The judge wrote in one statute. The judge could easily have written in both statutes.
Possibly, but he didn't.
Right, but that's.
Do you have any authority that Illinois is different from us and we
Well, you look to.
allow additions to the journal entries, or?
The state has the burden to provide facts to support that it's a comparable offense. The facts that the state provided were the indictment and the judgment. And the indictment says that in order to satisfy the elements of the crime, this is the conduct that he did. If you want to convict Joe of shooting at Sue, you can't prove that by saying that Bob shot at Sue. You're saying we're only looking at Bob shot at Sue. Well, you're not gonna be able to convict Joe then, okay? If you want to convict Joe for Bob shooting at Sue, which is what we're doing here.
So is the equivalent of your argument that we are now looking at a modified categorical approach and we have to look to facts? No.
My argument is that it is an element, and that's what you said. It's not a different crime. It is simply a theory that satisfies the element. So it's substituting for the element. So instead of saying Bob shot Sue, you're saying Bob, for whose conduct Joe was responsible, shot Sue. That's what gets you there. So when you're saying that for his conduct he was responsible, you're substituting in an element of crime. It's satisfying the element of crime.
So when the jury's instructed on the elements of an offense, it matters whether or not they're charged as a principal or an accomplice. Does the instructional language differ on the elements instruction?
Yeah, and that's what's confusing. Well, not confusing, but some cases it says that and that's approved, where another Joe did this and he's responsible for Joe's conduct. So then you know that's what the jury's finding because it's in the instruction. In other cases, it's a separate instruction that provides that John shot Sue, and there's a separate instruction saying you can be responsible for the conduct of another if, X, and this is what the jury would have to find. And what's difficult about that is there's been cases where they've given the foreseeability instruction in error, and this court has held it's not likely the jury relied on that because it's not in the instructions itself. It's set out separately. And so the jury's told about it, but you don't know if the jury actually found it or used that as a way to find the conviction, unless like a case like Overstreet where it's so obvious they had to rely on that. So it's basically, I don't think I can put it any other way. I mean, you have case law that says it's a factual circumstance that proves the crime, but it's really a substitute element in my mind. It's a substitute for, because it has to be a substitute element because you're not the one who's committing the act. In this case, the Illinois alleged that a person who Mr. McCray had entered into a common design with fired at a vehicle occupied by a police officer. So the only conduct that really they had to prove with Mr. McCray was that he participated in this common design or scheme. So he's not, it's a different, that just has, that substitutes in for, he didn't do the act, he didn't do the shooting, but he's responsible for this other guy doing the shooting. So he did it, or he did it, or somebody else did it, he's responsible for it. It substitutes in as an element.
Right. So to me, it's pretty clear that, you have, this conviction, okay, of a crime, and there are elements. And then over here, you have a theory of liability. So, but Kansas says you're supposed to be looking at the elements of the conviction, not the theory of the liability.
In terms of scoring criminal history?
Right.
Okay, and I would kind of disagree with that because the statute says comparable offenses under the Kansas Criminal Code. The theory of liability is part of the Kansas Criminal Code. And you can't get an offense by Mr. McCray unless you unless you combine the statutes, as you do with an attempt. You combine the statutes. You've got to look at both statutes in the code.
But on an attempt, you're usually convicted of attempted aggravated burglary.
Right.
And that's the conviction.
Right. They're not directly analogous.
Right.
But it's that same sort of thing, because, as you said, the jury has to make that finding. The jury has to find, for example, in Kansas, that you aided and abetted somebody in committing X crime. But
it's pretty clear, as the chief noted, that that's like a modified categorical approach. The whole point is to be consistent with the Sixth Amendment. We're only looking at the elements. We're not looking at any facts.
But this is an element. This is an element. It is an element because it's who did the crime. Who did the crime? If you only look at the elements, he didn't do the crime. I mean,
the elements of what crime?
The Illinois crime. And
no, because under this theory of liability, he's convicted of that crime.
He's convicted of what he pled to in the indictment. And what he pled to in the indictment is that he is accountable.
But then we have to look at the underlying record. I mean, for years and years now, we're comparing statutory elements to be consistent with the Sixth Amendment.
But you also look at the underlying record to figure out which elements are applicable. You don't just look at the whole statute. You can go beyond that and look at the documents in the case to narrow it down.
Not unless it's a, what is that called? A split crime, or, not unless it's a, I forgot the word.
But we're in that same sort of situation. So what you're talking about is, for example, was it burglary of a residence is a person felony? Burglary of a car is a non-person. So when you get an out-of-state burglary, you look at the charge, you look at and you see, was it burglary of a car? Was it burglary of a residence? You're going into the conduct, you're going into the elements.
No, you're going into their different subsections in the statute.
Yeah,
Right.
Divisibility maybe is the word you're looking for.
Oh, thank
The
you.
divisible
Right.
crime.
Right, but again, you can't, the offense is not just the statute, it's the statute combined with the theory of liability. Those work together to make it a crime.
So are you saying that the aggravated discharge of a firearm in Illinois is a divisible?
No, I'm not saying that. And again, I'm saying that you look at the indictment and it's saying that.
But we don't look at the indictment. We don't look at charging documents or theories of liability. We look at the elements of the judgment, the conviction.
Okay, and what I'm trying to say is that this is an element. This is an element of the conviction. That's what I'm trying to say.
How would your theory work if the jury have it instructed under both theories of liability, and then there's just a general verdict of, guilt?
Mm-hmm. Yeah, and that's what's difficult, because if it's not in the instruction for the jury to find, if it's just offered, then you don't know.
Right.
You don't know if the jury relied on that or not. So that's more difficult. But here
We know that from the plea.
well, here we clearly know, because that's what the indictment says. And you've got a judgment that says he pled to the indictment. I mean, that's there in the judgment. The judge, you might not have written out the statute number, but it was in the indictment. And you also have a judge saying, a journal entry that says he pled to the indictment. And it's all in the indictment. Everything I'm alleging of the two crimes are working together. And he's convicted under this common design. So that, I mean, that's clear from looking at the judgment itself, because the judge is saying he pled to the indictment. I mean,
Would you agree that if we get beyond that the Illinois statute is actually narrower than the Kansas statute, in that the Illinois statute requires the occupant to be a peace officer or police officer, whereas the Kansas statute is really broader. It just requires a human being be the occupant of the vehicle. Just seems to me that if we get to that point of comparing the statutes, Kansas is actually broader. Is that right?
That's right, right. Because it's any person in the vehicle.
Right.
But then I understand you argue it is not as narrow when we add the question of the theory of liability.
Right.
Because that is.
Kansas has to also find that it was reasonably foreseeable to the person, to the aider and abetter. So in distributing the marijuana, it was reasonably foreseeable to me that the other, somebody's gonna pull out a gun and shoot at somebody, that additional act has to be, whereas in Illinois, it's like felony murder. You're doing the one act, so anything else that happens.
So
That's
to
the
just
difference.
state it pretty more straight, in a more straightforward manner. If we just look at the elements of the criminal discharge, you lose.
And I'm not
But
making
if
that.
we,
Right,
so you agree with that. But if we add in the theory of liability, you have an argument for
right,
it.
because my argument is you don't have an offense. The only way you have an offense is if you do that, is if you, that's what's making the crime here. And I am out of time, unless there are other questions. Okay, thank you.
May it please the court, Chris Ailslager, appearing on behalf of the state. And once again, I'm making a pinch hitting appearance as the original counsel in this case has moved on to other employment, but I'm still around. Reviewing this case, though, I think the Court of Appeals correctly characterized Mr. McCray's argument in the very first line of the opinion, saying Xavier McCray asked this court to expand the classification of out-of-state convictions to include the theory of liability, not just the crime of conviction. And I think you all are, you've got that obviously, but that would be contrary to this court's holding in Wettrick. I think you've already recognized that as well. But I think, the language in Wettrick makes kind of clear why Wettrick went the way it did. And I think that if you were to go with the McCray's argument and expand the classification, it would unnecessarily complicate classification out of the prior out-of-court statements, muddying what I think is actually a pretty clear, straightforward test in Wettrick. And I would run counter to the very purpose of Wettrick. I think you'd rewrite or even overrule Wettrick, because it would then cause sentencing courts to, and there's paraphrasing from Wettrick, to utilize an imprecise ad hoc comparison of out-of-state crimes, leading to classifications based on guesswork and intuition. You can have judges kind of guessing, well, did the jury rely on this theory of liability or that one, as Justice Wall pointed out, or, trying to read the judges' minds, as Justice Lukert pointed out, that, the judge wrote down the statute. Now she says, well, maybe he could have wrote something else, but he didn't. He violated this statute. Those are the elements that you look at. Otherwise, you're getting into this imprecise guesswork of trying to read the minds of judges and juries and prosecutors, and so on. As was pointed out in the brief, the prosecutions aren't even required to put the theory of liability in the charging document. They just charge, so and so committed this crime, and then they can get an aiding and abetting instruction in our state at after the when it goes to the jury. The same apparently goes for Illinois and several of the other cases that were cited in the brief. So again, you're looking now at really almost arbitrary results based on how the prosecutor decides to write out the indictment. I mean, if you were to go to that point, but I think Justice Sanders pointed out, we don't look to the indictments unless we have like a divisible statute where you're looking at, is this burglary of a dwelling or something like that. Wettrick tells us we just look at the elements of the crime, and you look to see whether the elements of the out-of-state crime are identical to or narrower than the Kansas elements of the crime. It doesn't say anything about theory of liability, and in both Illinois and Kansas, the theory of liability is not considered a separate crime. When opposing counsel was talking about that, I recall from the brief, there's a quote from this court in State v. Betancourt that says, such statutes are merely an assignment of criminal responsibility rather than the creation of a distinct element of a crime. So this court has already said that theory of liability is not an element of the crime. So to get to what Mr. McCray is arguing, you either have to overrule Wettrick in some way, or you got to overrule Betancourt in the other line of cases in some way. And there's not any real sensible reason to do that. In fact, doing it would be, I think, counter to common sense, because you'd be back to muddying the waters and leading to the sort of arbitrary classifications, uncertainty, and guesswork in sentencing. So, I mean, at this point, I don't think I can say any more. I mean, that's the bottom line. I think the Court of Appeals got it right. They were correctly following this court's precedent in Wettrick, and there is no reason to go down the path that Mr. McCray is asking this court to do, as that would just simply introduce a whole new area of uncertainty and guesswork into the whole process again, which is what Wettrick was intending to stop, right? So if there are no questions, that concludes my argument. I just simply ask the courts to affirm the Court of Appeals. Thank you.
Thank you.
I would just respond that in this case this court has talked about the purpose of the sentencing guidelines is to make sure that people are treated uniformly and that the scoring of criminal history is important to do. And you want precise scoring. So Mr. McCray is going to be scored as a felony here. The question is whether it's a person or a non-person. So you're basically saying that we're going to count this as a person felony, which is not good in Kansas. A crime. It would not be a crime in Kansas. That's the result here. He would have a non-person felony. And if in Kansas, this conduct would have resulted in the distribution of marijuana, that's all it would have resulted in. Unless they could prove the reasonable foreseeability for the shooting. So in Mr. McCray's mind, he's distributing marijuana. And then he's convicted on this theory that because he's distributing marijuana or doing some other design or conduct, there's other things resulting, and you just wouldn't have that conviction in Kansas. I mean, that's the problem here. And I don't think there's uncertainty or anything. The state pretty easily presented these documents. And we're just going on based on this case. In other cases, the state may present documents that just don't give us this detail, and all it's going to do is show a statute number. And then the defendant can do what they want to try to contest that. But based on this case and the documents that were presented in this case, it's pretty clear. So we would ask that you vacate the sentence and remand for resentencing without the scoring as a person instead of non-person felony. Thank you.
Thank you. Thank you to both counsel for your arguments. Court will take this matter under advisement.